Trump floods LA with troops. Newsom calls him Donald Taco. California will draw new beautiful maps to fight Trump. A general says Trump grilled his loyalty after refusing a public park raid. And a court fight could decide if the White House can redraw US cities into battlefields. California Governor Gavin Newsom is launching an aggressive counterattack against President Donald Trump's administration, threatening to redraw the state's congressional maps in response to what he calls Trump's missed deadline on redistricting negotiations.
Donald Taco Trump, as many call him, missed the deadline. California will now draw new, more beautiful maps. They will be historic as they will end the Trump presidency. Dems take back the House.
The governor explained his use of the term taco, which he said stands for Trump always chickens out, prompted by the president's pattern of flip-flopping on deadlines. Newsom's office continued the attack, writing,
Big press conference. This week with powerful Dems and Gavin Newsom, your favorite governor. That will be devastating for MAGA. Thank you for your attention to this matter. GN.
However, Trump administration officials are pushing back hard against Newsom's political maneuvering. Border czar Tom Homan told Newsmax on August 12th that California's governor won't be able to obstruct federal immigration enforcement.
Governor Newsom is not going to stop President Trump and the men and women of ICE and the men and women of the Border Patrol from doing their job.
Homan argued that Newsom should be supporting federal law enforcement rather than hindering their efforts.
Bottom line is Governor Newsom should be thanking ICE agents for taking thousands of public safety threats off the streets of California. He's the governor of that state. His number one responsibility is the safety and security of his communities. So he should be shoulder to shoulder with us on this.
Republican Congressman Kevin Kiley from California has emerged as one of Newsom's harshest critics, telling Newsmax that the governor poses a unique threat to democracy.
He is trying to overturn the will of voters who put in place an independent commission by drawing a hyper-partisan map that will reduce Republicans from 9 out of 52 seats to about 5%. Even though we get over 40% of the vote in statewide elections, we need to stop Newsom's scheme in its tracks.
The political tensions between California and the Trump administration have now moved into federal court, where lawyers are arguing over the president's controversial decision to deploy thousands of National Guard troops and Marines to Los Angeles during immigration protests earlier this year. The legal battle centers on whether Trump violated a 150-year-old law that restricts military involvement in civilian law enforcement. California's attorney Megan Strong presented a damning case against the federal government during Tuesday's court proceedings. Strong told U.S. District Judge Charles Breyer in San Francisco,
"The government wanted a show of military force so great that any opposition to their agenda was silenced."
She argued that having what she called a standing army in Los Angeles was unprecedented and violated deep-rooted policies against military involvement in civilian life. Strong described the impact on California residents, stating that
they have been forced to endure anxiety and fear caused by the pervasive presence of this standing army.
The state's legal team contends that Mr. Trump and Defense Secretary Pete Hegseth acted as though
they can disregard that policy on a whim.
The federal government mounted a vigorous defense of the military deployment. Justice Department Attorney Eric Hamilton countered that there was substantial violence in Los Angeles that justified military intervention, arguing that the troops were only there to protect federal agents and property. The administration's sole witness, Major General Scott Sherman, who commanded the Guard Task Force in Los Angeles, testified about the military's careful approach to the mission.
We took our duty very seriously, and care and professionalism was always exhibited. The military personnel were instructed that we were not conducting law enforcement operations and that we were there to serve the United States.
The legal arguments have focused heavily on the Posse Comitatus Act of 1878, which generally prohibits military personnel from carrying out domestic law enforcement duties. California's lawyers alleged that federal troops violated this law by providing armed security for federal agents, setting roadblocks and perimeters that restricted civilian movement and detaining civilians. The ongoing trial has revealed previously unknown internal conflicts within the Trump administration over the use of military forces in civilian operations. Testimony from Major General Scott Sherman has provided rare insight into disagreements between military commanders and federal immigration officials over the scope and necessity of military involvement. Sherman disclosed a particularly telling exchange with Gregory Bovino, the chief patrol agent of the Customs and Border Patrol's El Centro sector, who questioned the general's loyalty to the United States after Sherman expressed reservations about a planned military operation at MacArthur Park in Los Angeles. When asked directly by California's lawyer whether Bovino had questioned his loyalty to the country, Sherman answered simply, yes, without elaborating further. The general explained his initial opposition to the Father's Day operation, noting that intelligence showed minimal threat to federal immigration agents and that the proposed operation would have sent military vehicles through the center of the public park. Judge Breyer allowed this testimony over Trump administration objections, calling it a notable window into the mindset of key decision-makers. Sherman's testimony revealed the extensive scope of military involvement in civilian law enforcement operations. He testified that over 2 months of deployment, the National Guard was requested for assistance 64 times, participating in over 170 law enforcement operations carried out by several different federal agencies. The trial has also exposed what legal experts are calling the protective power theory, a controversial interpretation of executive authority that the Trump administration has used to justify military deployments. Sherman testified that Department of Defense attorneys told him there was a constitutional exception to the Posse Comitatus Act that allowed prohibited activities because they were in line with Trump's orders. When Judge Breyer pressed for clarification about this exception, Sherman acknowledged he's not a lawyer, but said he was advised that the exception was triggered because Trump had declared the Los Angeles protests a form of rebellion against federal authority. Judge Breyer appeared skeptical of some government arguments, particularly regarding Trump's authority to unilaterally declare situations as rebellions.
If he calls something a rebellion, it is a rebellion.
Legal experts note that this broad interpretation of presidential power could have far-reaching implications for future military deployments in American cities. The trial comes as Trump has already deployed National Guard forces to Washington, D.C., and suggested similar actions might be taken in other Democrat-controlled cities like New York and Chicago.